Good afternoon, everyone. Welcome. Welcome for those in person to this newly refurbished, beautiful room in our ILO headquarters. We're extremely happy to have our seminar today. So welcome ILO colleagues, members of the academic and practitioner community who share a profound interest in labor rights and migration. Today, we are particularly honored to welcome our distinguished guests from the European Birds of Passage Research Project hosted at the University of Strasbourg. Marco, Daniel, Audrey, and Catarina, thank you very much for being here today. Welcome to the ILO. Your presence enriches really our dialogue and strengthens the collaboration between research and policy in advancing decent work for migrant workers. So I will say just a very brief introduction of why we're here today. You might be wondering, why temporary labor migration in Europe? Well, as many of you know, the ILO has a long-standing engagement with the topic, rooted in its constitutional mandate to protect workers in countries other than their own, in other words, migrant workers. The European Union is then a fantastic laboratory to explore the diversity of migration and its implications for the protection of social and labor rights across different categories of workers, mobile, seasonal, posted, and we'll discuss a lot more of these. Early this year, together with my colleague Christiane Kopt, who is with us here today, thank you, Christiane, we published an edited volume entitled Temporary Labor Migration Towards Social Justice as part of our strong collaboration between the Research Department and the Labor Migration Branch. The book examines both the potential and the barriers that temporary forms of migration present for achieving social justice through decent work, among other important topics. But one of the key findings of our collective research was that, or is, that definitions matter deeply. They carry significant policy implications, and the effort to clarify them is far more than an intellectual exercise. Indeed, who counts as a temporary migrant determines the extent of the protection such a worker can claim, and ultimately shapes how these rights are recognized and enforced in practice. So today we will learn about different cases as they manifest in the European Union by addressing the situation of posted workers, that is, an employee who is sent by their employer to work temporarily in another EU country to provide a service while remaining employed and paid by the company in their home country. For instance, just to give a few numbers, if we take 2023 as a reference year and data for 25 countries, the European Commission reports 1.5 million posted workers and 4 million postings, both from within and outside the EU, considering the national prior declaration tools that we'll hear more from Daniel about all these data challenges of capturing these movements. Also, we analyzed in one of our ILO from Theory to Practice webinars as part of our labor compliance research project, when we studied the case of the European Labour Authority. This you can all consult in the ILO website, that despite existing legal frameworks, many challenges remain in enforcing the protection afforded to these posted workers. We will also learn about seasonal workers in the agriculture sector of Spain and France, as Audrey will reflect on the role of the ILO conventions in the regulation of this group of workers, and Catarina will share preliminary findings on her work with au pairs, also in France and Ireland, and the potential of ILO Convention 189 on domestic workers to improve legal protections in these selecting countries. All these presentations share in common that they all address one dimension of temporariness. In the European Union in particular, Marco will relate these manifestations of temporary forms of migration with thinkings or conceptualizations of the labor market. So the European Birds of Passage Research Project is rooted in legal research, but not only, this is what makes it so fascinating, by engaging with other disciplines such as legal geography, economics, sociology, and political science, Marco and his colleagues invite us to rethink who is inside the labor market and therefore question the boundaries of the labor market in the European Union. In this way, the projects open an interesting inter-cross-disciplinary dialogue with approaches in economic and political geography that have already alerted us that the idea of a single labor market is a misnomer. Again, this is not merely an intellectual exercise. Focusing on who is inside the labor market has profound implications for how temporariness is defined and then accesses labor protections and social rights, and ultimately for ensure that these rights are realized in practice, not just recognized on paper. So finally, I would like to thank you all for your interest in this topic. I warmly invite you to engage with the presentations and contribute to what I hope will be a lively and thought-provoking debate on how we can develop smarter, more effective policies for the benefit of all of our ILO constituents. So before moving into the presentations, I just want to give some housekeeping rules. For those who are online, you're welcome to post your questions in the Q&A section. We prefer the Q&A rather than the chat. But also, if you would like to raise your hand, we will make every effort to accommodate your request to give you the floor. Presenters, we have around 15 minutes each, and we have decided to divide the session in two parts so that we can have ample space for discussion and engagement with the authors. And I would like also to thank Alessandro, who's sitting next to me, who always been this human digital brain that allows us to be all in communication today. So thank you, Ale. So without further ado, I will present the first two authors quickly, and we delve into the presentations. So Marco is permanent researcher in labor law at the French National Center for Scientific Research, CNRS, affiliated with the DRES research unit at the University of Strasbourg, and is a principal investigator of this project, European Birds of Passage. His research focuses on temporary labor migration in the European Union, the impact of EU economic governance on social rights, and the interaction between European and international labor standards. He has participated in several European projects on labor mobility, industrial relations, and social dialogue. And Daniel Elanga Mendogo, sitting next to him, is a postdoctoral researcher with the European Birds of Passage project. He holds a PhD in economics from the University of Lorraine, where he specialized in applied behavioral economics. His current research explores the labor market effects of European labor mobility policies, including the European Union's 2018 Posting of Workers reform. His broader interests include migration, development, and social integration. So the floor is all yours, Marco. Welcome.
All right. Okay. I see the slides coming up. So thank you for the kind invitation. Thanks to the International Labour Organization for the invitation, and especially to Fabiola, because not only she invited us, but she organized all of this and taking time to see that everything works perfectly. So thank you very much for this. So I have a double duty today. First, I will briefly introduce the project, European Birds of Passage, and then I will come to my own presentation. So European Birds of Passage, you see today represented 4/5 of our team. So we are a small team, and yet we are a mixed methods, multinational, multilingual, and multidisciplinary team. So the project itself focuses on temporary labor migration in the European Union, as it has been said. It has a focus on social rights, as I am a labor lawyer, and tries to bridge the gap really between the generally good amount of empirical research that now we have on temporary labor migration and the legal representation, legal symbolization of temporary labor migrants. Essentially advancing the idea that there is indeed a gap in our laws, and in our case, in particular, EU laws represent temporary labor migrants in their relationship, in particular, to time and space. So you can see here already on the slide that our scope is somewhat strange for lawyers because we deal at the same time with migration inside the European Union, posting of workers, and migration from so-called third country nationals. So for social scientists, this is not particularly strange. It's still migration. But for lawyers and my friend generally immediately balk when I speak about our scope. However, this is justified by several elements. There are shared vulnerabilities of intra-EU migrants with migrants from third country nationals. The recent attention from the European Labour Authority to intra-EU seasonal workers is proof. They have a similar position in labor markets. In fact, they are often substitute. We have seen this perfectly with the 2004 enlargement, where intra-EU migration essentially replaced migration from third countries for many years in certain sectors. And there is a growing overlap where posted workers are increasingly third country national posted inside the European Union. Around a fifth or to a quarter of posted workers is actually a third country national. So there is a migrantization of intra-EU temporary labor mobility. And fourth, similarity is their, let's say, complicated relationship with the principle of equal treatment, where temporary labor migration is construed very much as an exception from equal treatment. It can be about working conditions or access to social security. And this complicated relationship is sometimes also reflected in ILO conventions. And it also has led to a conflict of standards between the European Union, so EU law, and the law of the Council of Europe, embodied by the European Social Charter. But we have more or less forgotten about that. It's still there, the conflict. I will not go into details about this, but if you are curious, please ask. So the aim is to explore how legal symbolization naturalize categories and shape perception of who is a temporary labor migrants, because law calls something a temporary labor migrants, whereas empirically speaking, we know quite well that the phenomenon itself is indeed pretty permanent and structural. So can the law, and in particular EU law, give justice to the permanence of temporary labor migration and the contribution of temporary labor migrants to the labor market of countries of destination? How can we address the obfuscation by law of their situation and make the law less of an obstacle on the quest towards social justice for temporary labor migrants? So coming to my own presentation, so I have the honor of being the principal investigator for this project, of directing the work of these amazing researchers. So they have all the fun stuff with the empirical data, qualitative and quantitative, and I will give you concepts. So bear with me, it's not just an intellectual operation. We have heard about the importance of definitions. So my presentation today focuses on spatiotemporal scales, which is the spatial and temporal elements used to identify temporary labor migrants. And my first part is the space. Here comes the surprise, because my identification of the space of destination of temporary labor migrants is not the physical space or the crossing of geographical borders, which in itself is intertwined with migration, so it might be surprising not to deal with it. But instead, I consider the space of arrival as the labor market, because in many of these cases, crossing the border in itself would be possible, sometimes even easy for intra-EU migration, uneventful. But the access to the labor market is what really matters for these trajectories of migration, and that's where the law intervenes. And so all of these forms of temporary labor migration have a relationship with the concept of labor market, be it in the law itself, in impact assessments, in the case law defining it. So my question really is, what does labor market even mean for a lawyer? Because of course it's not a legal concept per se, it's not defined by these instruments. So to do this and to try to put a definition on the labor market, we operated together with Audrey a systematic document analysis of all EU law mentioning labor market to try and understand just what do you mean when you say labor market, and if we can we identify a legal border of the labor market? Who is in, who is out? So I will not bore you with the details on the review. We have a paper published which goes into the protocol. The data is all publicly available and linked on the project website. So the idea was we blind and separately coded all dimensions of labor market according to several predefined categories, and the result, much for a lot of empirical legal research, is not a surprise, but it helps us to understand something. So the most used definition is what we defined as textbook economic definition, which is the labor market is, of course, a market where demand and supply meet, and they set a price for labor. And digging deeper into some of these legal documents, we see a connection with the idea of replacing local workers. So if a migrant worker does a job which would be otherwise done by a local worker, then they are inside the labor market. And now the reaction would immediately be, well, then they are all inside the labor market, because, of course, most of the jobs need to be done. So Okay, that's a conclusion. I don't disagree. But in terms of setting our definition, the focus should be on the supply of labor. And this is an interesting perspective, especially if you look at intermediaries. Much of temporary labor migration is mediated by intermediaries. In fact, we could almost say that all temporary labor migration is mediated by intermediaries. So my question with this first definition is, does the border of the labor market start from the point where the worker is in the list of this intermediary? From the moment that an intermediary is ready to supply the worker to the country of arrival, then maybe these workers are already in the labor market of the country of arrival because they are available to provide their labor force. Now, coming to time, and of course, time is much more evident, the relationship between temporary labor migration and time. Indeed, it's quite clear. Temporary labor migrants feel the most brutal application of temporal governance to their migration. Here we have a difference in the categories where migration from third country national is assessed through what I call thick time of migration with pre-established duration, whereas posting of workers being considered as part of business activity is attracted into the thin time of business. Why is it thin? Is because there is no ex ante limit to the duration of these migration, employer organized migration, but migration nonetheless. So this is only assessed from the end. It must be temporary, but we cannot say how long should it last or can it last. And the Court of Justice has never accepted that member state put a hard limit of how long can this be. However, and this is the interesting point of looking at migration as well, in the case of posted third country nationals, business mobility meets migration because there is a movement, intra-EU movement of third country national. And there has been a case, a recent case in the Court of Justice, where the court has accepted that temporary, so intra-EU posted workers from third country national can be asked to acquire a residency permit. And the duration of this residency permit can even be shorter than the provision of services by the business who is sending them. So in a way, the logic of migration has prevailed over the logic of the internal market. Not that any of those is very conducive to social rights, but that's a different story. And we have seen temporal governance applied to posting of workers in the case of posted third country national. So my question here was to try and put a number on temporary. How long is temporary according to EU law? This is again a systematic document analysis, still unpublished, but the data is already available online. So how long is it? The answer, it's a much smaller corpus, focusing on the use of temporary, limited duration, similar concepts under EU law. It's a smaller corpus, and it's quite concordant. So even though it's smaller, it's quite clear. Generally, a temporary situation is below 1 year. And we can see here the co-construction between law and our perception of reality mediated by statistics, whereas a lot of statistics on migration have this 1 year cutoff in order to be counted even as a migrant in the country of arrival. So we see how law does not only regulate the migrants themselves, but in a way impacts our perception of who is a migrant and how do we count them. And then who is assessed through this thick time. So where do we find temporal limits is again mostly human migration and not business mobility. And the third element, which is something I was particularly interested in because of this influence from legal geography as well, is the scale of temporariness. So at what scale is temporariness assessed? And what I mean by this is, so the micro level is the individual migrant, and the meso level would be the employer or economic activity. So, of course, the results, again, are quite clear. Now, the law focuses on the individual. Not a surprise per se, but if we compare to the empirical knowledge we have on temporary labor migration, we can see immediately how this is quite problematic, because, of course, when you hyper-focus on the individual, you can always find temporariness. In the end, all migration is temporary, potentially, even the most permanent one, and we have seen it challenged in recent times. So if you hyper-focus on the individual, you will always conclude, yes, this is temporary. But if you zoom out and rescale your focus, you might have a different conclusion and might be able to take into account a broader phenomenon. And I'm happy to say that these three elements you see in the slide, three elements where migration is assessed through a collective scale, so a mesoscale, they all come from labor law or social security instruments. So I want to finish this on the, let's say, things that we can learn from my discipline, and often interdisciplinary dialogue for a lawyer generally means we draw something from other sciences and we are there to learn. But sometimes the law can teach us something in terms of tool to address certain situations. So these two legal rescaling examples come from posting of workers, and in particular deal with replacement. So I will not go into details, but there are temporal elements in posting of workers. And if you replace a posted worker with another one, the EU law itself has tools to avoid circumvention, tools which rescale the legal focus and say, no, if a posted worker replaces another posted worker, then the clock does not reset. Or, if a posted worker replaces another posted worker, then they are immediately affiliated to the social security in the country of arrival. So there is an attention to a situation which is not the individual worker, because the second worker is temporary, of course they are, but they are part of an economic operation that goes beyond their temporal presence, and the law is able to take this into account. So this is what I want to draw from our strange, weird scope that covers both intra-EU and extra-EU migrations, that we can draw teachings and insights from both fields to address a situation which has a lot of similarities. And in this sense, this has an immediate potential effect, but it has also an impact on our legal symbolization and reducing the obfuscation of the temporariness of these workers. Now, there is also interesting recent evolution, and I finish, where the Court of Justice has recently opposed systematic to temporary. So there is let's say, a legal malaise, if you want, about the stretching of this legal fiction of temporary labor migration, where we keep calling something temporary, which is absolutely permanent and structural in our economies, and sometimes in essential sectors of our economy. And the hope, very modest, but at the same time ambitious, of European birds of passage is indeed to provide a vocabulary to be able, as lawyers, be it judges, policymakers, and so on, to discuss this and to take into account the growing empirical evidence about the relevance of the presence of temporary labor migrants, and to give it a legal meaning. Thank you for your attention.
Thank you, Marco, for this introduction. That we'll come back to you. I'm sure there's a lot of questions in the room, but now we give the phase. We'll learn more about this personalization in the posted workers case. So the floor is yours, Daniel.
Yeah. It's the blue one. The blue lower. Below. Oh. There you go. Yeah. Yeah.
Okay, perfect. Hello, everyone. First of all, following Marco, I would also like to thank the ILO for hosting us here today. Extend this gratitude to Fabiola and everyone who helped organize this seminar. And finally, thank you all for joining us, whether you're in the room or online. So my presentation will be about the European Posting of Worker Directive, and especially its 2018 revision, with the objective to address the topic of how has this reform affected the level of posting of workers' activity and the remuneration of posted workers. So beyond the preliminary descriptive statistic I will be presenting here, I will also share some feedbacks on the challenges we have faced so far in conducting this quantitative study, which I believe to some extent those challenges also explain the gap we observe between the importance of this form of migration and the limited available quantitative knowledge on this migration. Okay, as a brief summary, the 2018 reform of the Posted of Workers Directive aimed at providing greater protection to posted workers and improving the employment terms and conditions of these workers. And one of the most important or also controversial amendment of this reform concerned the legal framework on the remuneration of posted workers. So typically the reform shift the wage framework of posted workers from a minimum rights paradigm to one based on equal treatment with local workers. And when we see the vote outcome on this proposal, it might suggest that there was a broad approval of the policy across EU, but in fact, the policy was adopted following decisive debate between member states and also significant opposition of employer organization across most EU countries. So the idea here is that after 5 years of implementation of the reform, it's a right time to conduct, let's say, at least a midterm assessment of how this reform worked in practice. So I will first jump into the research challenges we have encountered so far. And let's say the main one concern data. So in 2014, the EU adopted an enforcement directive which called member states to facilitate data collection and data availability. But since now, most member states have not, until now, most member states have not complied with these requirements. And the two good examples, let's say, are France and Belgium. But still, even when you have to collect data from these two countries, it is not a straightforward process. So here I'm going to give a brief example of what we experienced in the French case. So requesting data and posting of workers took us almost a year. So our initial request was submitted in December 2024. Then we have to wait more than 3 months to receive the approval. And then again, 1 month to receive the IT equipment, which allow for a remote access to this data. And when all this was done, we still had to wait. When all this was done, when we started working on this data, we discovered that there was incomplete. So we have to contact the provider again to mention this point and to ask for a full data set, which took again almost 4 months before receiving the final data set few weeks, 3 weeks ago in the beginning of this month. So this is really an obstacle for research projects, for example, who will have limited deadline, and we cannot afford to take 1 year only to request the data. Another important challenge or constraint is the financial one. So even if in principle data access is free of charge, in practice, so to have access to data, as I mentioned previously, we need a whole IT equipment, and we have to pay a subscription for this equipment. So what we pay is an annual subscription which took more than 8,060 €. So it's really, I think it's really high and can be preventive for many researchers who could be interested in the topic, but unfortunately could not have the budget. So this is at the level of the data collection, the most important issues we encountered. And the next group of issues I would like to mention are more related to methodology and also somehow to data. So the first point I want to mention here relates to the way data on posting of workers is collected. So the approach is a self-reporting one, which means that companies enter all the information on how posting is going to be executed, including the duration, the wage posted workers will receive when they are on assignment. But this leaves us with the question about the sincerity of this data, because it is hard to, and we do not have instrument to judge whether what is reported in the data set is what is actually, for example, regarding wages, is what is actually received by the posted workers. So this is one limit on working on posting of worker and drawing conclusion about the enforcement of the policy. And the next one, the next methodological challenge concerns the fact that, okay, this reform of the posting of workers took effect in 2020, but this also coincides with the COVID-19 pandemic and related mobility restriction. So it will be hard to isolate the specific effect of the reform and from the one of the COVID-19 pandemic. So the statistics I will be presenting here are still very preliminary, and I will not draw any definitive conclusion at this stage. Okay, so now if we turn into these statistics, so what I'm sharing here is how posting of workers levels evolve before and after the enforcement of the policy. And the left chart presents the total number of posting declaration at the EU level, excluding and including Germany in the set of country. So this is done because at some point in 2019, Germany experienced a sharp increase in the number of posting declaration, which remains somewhat unexplained. So that's why it's important to compare how the total evolved with and without Germany. And in the right side, we also observe the evolution of this number of posting declaration, but here we separately analyze countries, or let's say bilateral flows, which are likely to be exposed to this policy. So these are those flows who concern workers moving from low-wage countries to high-wage countries, and flows that are likely not to be exposed to this policy reform. So generally flows from high-wage country to high-wage country, or high-wage country to lower-wage country. And what this trend shows for the two graphs is that, okay, we observe a decrease in posting in 2020, but then starting from 2021, the number of declaration of posting of worker progressively recovered. And when we reach 2023, in all the scenarios, what we see is that the number of posting in 2023 is already, the number of posting declaration is already higher than that of the pre-pandemic and pre-reforms level. So this will be mainly in line, let's say, with a transitory effect, which could be the COVID-19 pandemic. But as I said, I will not draw at this stage any definitive conclusions. And then, what is it?
Are you in this now?
Turn it.
Oh, it's just that the mouse is outside of the. Yeah, we're back.
Okay, perfect. Thank you.
Or should we? Yeah.
Okay. Okay, and then in this next slide, I also analyze the evolution of the posting of worker, but I use, first of all, a different measure of posting of workers, which is the number of posting of workers in full-time equivalent, because as Marco mentioned previously, so all posting assignments do not have the same duration and the varying duration. So to have, let's say, a measure of intensity of posting of work, it's also important to convert it in terms of full-time equivalent. So this is what I'm trying to do here, and still analyzing separately exposed bilateral flows and non-exposed bilateral flows, and the analysis focus here on incoming posting of workers to France. So what the figures show is slightly different from what we saw in with the number of posting declarations. So we still observe a decrease in 2020 in the number of posting of workers in full-time equivalent. But here the decrease seems to be, I will not say persistent, but by 2023, we haven't recovered the level of posting of workers before the policy reform and before the pandemic, which could be more in line with, let's say, permanent effect, so which could support the idea of a policy effect. But again, no definitive conclusion at this stage, and additional work will be conducted before that. And finally, the last question I will address is about the enforcement of this policy, notably concerning the wages of posted workers. So the question here is, okay, how did posted workers' wages evolve before and after the pandemic? And again, so it's very preliminary. So I took a sample of the wage data in the French, of incoming posted workers in France, because the data need more cleaning. So I took a sample of this that we could analyze, and what could appear from this chart, it's a priori, we can say that the wage increase after the policy reform seems to be sharp than the one before the reform, so which could be, let's say, suggestion of the fact that, okay, employers indeed or effectively increase the wages of posted workers. But again, as I said, these are reported wages. I don't know if it is us reporting to be in accordance with the policy of it's a real increase of the wages of posted workers. So the work is still ongoing, and yeah, I hope in the next couple of months to be able to bring out more causal and more definitive results. But yeah, for today, it's all that I can say, and yeah, I will end here, and thank you for your attention.
Thank you very much. So now, I see a few questions, but I would like to give the floor to participants in the room first, to make their comments or reflections or questions, clarifying questions as well, on concepts that have not been maybe clear or require further explanation. And I will check in here as well. Who would like to go first? Yes, Dorothea, and then Uma.
I just have a question for Daniel. I would like to know, what is the current minimum wage level in France?
I would say the gross wage, it's it's around 11.52 if I'm correct. The gross minimum wage it's at that level, yeah.
Okay, so it's really significantly higher than the minimum wage. The whole development.
Yeah, the figures, yeah, we observe, yeah.
As a complement to that, that's of course the legal minimum wage,
Yeah.
but sectoral minimum wages, because of extended collective bargaining agreements, can set a higher floor. So not all posted workers will be in a sector where it is the legal minimum wage, it's the actual floor.
Uma, please. Yes.
Yeah, thank you so much for coming and talking to all of us. I have two questions to Daniel, actually. Quite interesting, quite shocking to see that the subscription is 8,600. That's really crazy to even think about how you can go about doing continuous research over the years. The question I have is, I want to know a bit more whether the data allows you to look at it. Who are these posted workers? You know, which category of staff are you talking about? and also which sector do they belong to? I think that would be quite interesting to note. And if I remember right, when you were showing the EC directives and the one that, you showed saying, they wanted to revise it, the point that was being raised is that the posted workers should get the same wages as that of the local employees, right? So here, when you do show an analysis like the hourly wages, I think what would be quite interesting to see is whether the wages that the workers get is equivalent to because that's where you're getting into the equal remuneration, right?
Yeah.
So I think it would be quite interesting to see whether you've already done some work around that and if you can say something about it. I have a question to Marco too, if I can. And I'm just wondering, listening to you in a way, something that we always, coming from the developing world, we always talk about the EU as a fortress in itself. Like, it doesn't really allow other third world countries or developing countries to come in easily. And the only way you can enter is probably either through the intra-corporate transfers and also the posted worker kind of a scheme. And there, for me, I was not very clear when you went about talking on the replacement does not reset the clock, and replacement means immediate affiliation to Social Security. Like, what does that mean within that context when you have migrant workers from outside the EU? Thanks a lot.
Yes, please go ahead.
Yes, I have another question to Marco, please. You raised this very interesting question about defining labor markets from a lawyer's perspective. And amongst other things, you said, you raised this question, is someone in the labor market because they are on a list of an intermediary, right? Do you have a preliminary answer to that?
Okay, yeah, I completely agree with the let's say the second point of the idea of comparing with local workers, if indeed the wages of posted workers is effectively match the one of local workers. So I would have loved to have this comparison for today, but as I say, we received this data 3 weeks ago, and it requires very much cleaning before analyzing them because so we have a data set where you have some companies declaring hourly wage, those declaring daily salary, other ones declaring monthly and other annual. So there's a large work to try to uniform all these measures before being able to compare them. So I just took a selection of what we have in the data to present for today, but yeah, in the next week, the idea will be to effectively compare that with what of local workers. But the previous work, let's say, of another researcher before the implementation of this reform pointed a 30% gap between the wage of between posted workers' wages and local worker wages. So now the idea will be to see if this 13% have at least decreased or completely disappear. So that's what we are going to try to do in this project. And then who are posted workers? So they are mainly, I think, across Europe, not only in France, they are mainly manual workers, blue-collar workers in sectors such as construction sectors and mainly construction sectors. Yeah, I do not have the detailed statistics. Yeah, but the large majority is manual worker in construction, in agriculture also. Yeah.
All right. So the matter of how do you get into Europe and why very much how I was drawn to temporary labor migration in my research was very much that the more you close all other pathways for migration, the more, of course, these ones become attractive and even are to some extent repurposed. And the intra-EU posting of third country nationals is very much this example, where third country nationals will find the the country which allows them to move more easily because of bilateral agreements. This is the case, for instance, of Slovenia towards certain countries from the Balkans, the case of Spain for certain countries from Latin America, the case of Poland for Ukrainian and other workers from neighboring countries. So they can get into that member state, but then they cannot move inside the European Union. What do? Then they can be sent by their employer from Poland to another member state. So there is very much an effect where the more we make it impossible to go to all the other roads, the more these kind of situations will arise, giving really rise to an industry of intermediaries that facilitate these for reasons that can go from the mere gain to more forced labor and exploitation and so on. The question of replacement, it's only applicable to posted workers as of today. And the idea is that if you have a posted worker who is sent to, let's say, a building site, let's take construction as the most common example, they are sent there to do electrical work, and then they are recalled to the countries from which they were sent, and another posted worker is sent to do the same job, then this new posted worker should first not reset the clock. At 12 months, they get better equal treatment, let's say, more equal treatment, and also they are immediately affiliated to Social Security. This is also the case if a different employer sends them. So you can't avoid it by creating, another company. So the law is quite smart, and labor law, I think labor law has a lot to teach to the debate on temporary labor migration, weirdly enough. And of course, we are not the most fashionable discipline at the moment, so I'm not saying it will teach something, but it could, and it has smart tools to avoid all this sort of fatalism where, employer will just circumvent it. Well, actually, no, policies can have an impact. That's the thing, and we have tools. So finally, the role of intermediaries. Do you have an answer already? Okay, so this is more of a, I would say, more ambitious thinking that I want to do and I want to advance. But on one specific element, I think it can be interesting. So we have research about the fact that temporary labor migrants often contribute to Social Security, but they cannot draw anything from it. And one example is unemployment benefits, which are often linked to showing that you're looking for job opportunities in the labor market where you're drawing unemployment benefits from, which they cannot do because they cannot be there. But maybe you could argue that by being available through an intermediary, even though you're not physically there, you are looking for job opportunities in this country where you have paid contribution, let's say France, even if you are in Morocco, but you are available to an intermediary, you should be able to draw your French Social Security benefits for your unemployment. So this would be my first entry point. You can get even more ambitious if you want, but the labor market link is really in the unemployment benefits regulations, and I think there is an entry point in these extremely relevant presence of intermediaries.
I think before I give you the floor, it would be also very interesting to distinguish who holds the employment relationship among these intermediaries, because some of them are just brokers or placement agencies. So maybe looking at what we used to call the staffing industry, and looking at the different, giving more ideas, because I think for ILO is very important, as we have the fair recruitment initiative, and colleagues are making a lot of progress in different areas on this field. So there's a question online, and I will give the floor to Dagmar, and then I will read it.
Thank you so much, and thanks for coming to present at the ILO. This question is to Marco about the definitions, about the time. And you were saying that, temporary would be for the individual less than 1 year. And I was wondering if there are member states of the EU that allow for renewal. So basically, could you stay for more than 1 year, and what that would mean? Or do you have to really go back to the sending company when you've outplaced in the home country? And then in this definition of being available in the labor market through intermediaries, how quickly can you go back, or can it be in through the same company, or must it be another company? Or I was thinking about the individual. How long can this individual kind of stay in the countries and EU's labor market, if you have some idea about that. Thank you.
I think the question online is for both of you, probably. Would you say that the majority of issues coming up in practice regarding third country national workers posted within the European MS are the consequence of poor enforcement of EU legislation, or do you think there's still space to improve the framework to increase the level of social rights protection of TCNs?
All right. So about the 1 year. So this 1 year is about trying to understand what the law, in more broader sense, means as temporary. So it's not always the actual time threshold for the specific situation of migration. So as to the question, can they come back? Again, it depends. In case of posting, it's not a limitation in which posting has a maximum duration. Posting can be longer. There is no actual limit as long as it is temporary, but there is no threshold. After 12 months, it just becomes more equal. So you have the application of all labor laws and more collective agreements. And after 12 months, you have the affiliation to Social Security automatically. So there is an impact of time, but potentially could last for longer. We know from empirical data, most posting are much shorter than that. So it's more about trying to understand how the law influences collection also of statistics and so on. So in this attempt at trying to find a meaning behind a corpus of legislation and not going on one specific element, and more trying to understand a broader vision of what is temporariness. And in terms of can they be sent by a different company and so on, again, it depends. In the case of seasonal workers, there are now more countries experimenting with multi-year permits, which allow to come back the next year, reduce the administrative burden. And certainly this is, in my view, another sign of the permanency of temporary labor migration. Although in themselves, they are probably a step forward and something which should be celebrated for those attached to social rights for migrant workers. But it also signals the permanency, really, of the phenomenon. And then the point on enforcement, yes. So I very much, of course, agree with the gap in enforcement. It would be hard not to. Yeah, how much of that is by design in terms of the effect of austerity on labor inspection? Has been also ILO published research on the terrifying impact of the previous or 2 crises ago on labor inspections in particular. So yes, definitely we need much more enforcement. And in particular, I just mentioned one, sorry, I'm being too long in the answer, but I want to mention that the importance of remoteness and secludedness for temporary labor migrants, meaning the agricultural fields, the working building sites, the houses as private houses, as workplaces. They all have an incredible barrier to enforcement, to labor inspection, and so on. So yes, I don't absolutely not disagree, and with my work on concepts and on fundamental issues of substantive rights, I do not want in any way to say that this is all we need and we don't need also enforcement. I do believe we need enforcement. But I believe also the answer to enforcement is just that we need more money for enforcement. And this is not very interesting for me as a researcher, unfortunately.
Thank you, Marco. We have another question here. Following on your comment, if availability to recruiters may count towards benefits, if I understood correctly, it's an anonymous person, might this not risk restrictions on circular migration and opportunity to return?
Right. Okay. So I don't want to criticize the question in itself because it's a fair question, and yes, probably there might be an impact, but the actual. I don't think the impact would be that important for recruiters themselves. This is very much a cost for the receiving state, but a cost which should be a fair cost, because these are contributions which have been paid. We are not talking of anything else. So these are workers that have contributed to social security and that should draw the same benefits as all other workers. This is quite basic. So the argument behind such a question, however, is something I would like to address shortly, because I think the perspective of labor law, again, has been sometimes forgotten in these debates, where the cost of rights is often put against the number of migrants. And this is an argument which might seem an argument about migration, but it's really an argument about all social rights and all regulations. And that's why, as a labor lawyer, I find it to be a kind of a slippery slope, and why should not be available also to, unemployed people in the country saying, I want to work for below the minimum wage. That's a fair individual point, which labor law has had no problems for many years to just refuse. Say, no, we have socially accepted standards and we just work under these conditions. So in this sense, I think labor law has some contribution to this debate.
Thank you. I think it's now time to continue with our case studies on different forms of temporary migration. And we'll bring another important dimension, which is the gender dimension in these debates. So we have Katarina and Audrey. Katarina is a doctoral researcher at the University of Strasbourg and a member of a CNRS funded project, as you know, European Birth of Passage. And in her PhD, she examines the regulation of au pairing in the European Union, particularly in France and Ireland, with a focus on how gender and citizenship intersect in labor law. She holds law degrees from the Federal University of Uberlândia and the University of Sao Paulo in Brazil. And Audrey is a doctoral researcher at the University of Strasbourg and a member of the CNRS funded project. This project we're all gathered together again. And she investigates the social protection of migrant women in temporary labor migration schemes in France and in Spain. She holds a BA in law from Toulouse Capital University and a master's degree in law and gender-based violence from the University of Valencia. So the floor is yours.
So good afternoon, everyone. I'd like to thank you all for being here and the organizing for putting together this seminar, the opportunity to present and discuss some of my findings. All good? No?
Go on the slides.
Oh. Okay, oh good. So I present today part of my PhD research project. My point of departure is the legal construction of au pairs as a special category. So the European Agreement on Au Pair Placement of the Council of Europe illustrates this construction. It places au pairs as a special category, which is neither a student nor a worker, to which labor law protection might not have the same reach. So a model agreement followed the European Agreement, to which the intention is to govern the relationship between the parties, so au pairs and the so-called host families or employers. Au pairs are usually young women who move to a different country to live in a family's house in order to learn a language and have a cultural experience while providing childcare and housework. The host family / employer, in its turn, provides food, accommodation, and the so-called pocket money. Age, gender, nationality, and the invisibility of domestic worker are the basis for the construction of this idea of a special category or an ideal worker. The legal construction as a special category and the ways in which its discourse was spread constitute a vector of a vector of vulnerability to labor exploitation. And even though it impacts national models of regulation, as it may serve to legitimate exclusions in terms of entitlement and hide their access to social rights. So my presentation now turns to two national models of regulation of au pairs, their common challenges, and the potential of ILO Domestic Workers Convention. So France illustrates the first national model of regulation I'm presenting today. France was the first country to ratify the European Agreement on Au Pair Placement of the Council of Europe. After ratifying it, instruments that deepen the separation between au pairs and other domestic workers were nationally adopted. More recently, France has created a specific visa scheme and temporary residence permit for non-EU au pairs when transposing the EU Researchers and Students Directive. Non-EU au pairs can stay up to 2 years in the country within this scheme. French law refers to jeunes au pair, so non-EU au pairs, and stagiaires aide familiale étrangers, which are EU au pairs. Both of them must sign model agreements which intend, as I said, to govern the relationship between the parties. The model agreement, this is the official model agreement provided by the Ministry of Interior. The model agreement states that the working hours, which are limited to 25 hours per week, pocket money, since 2019, the minimum is 320 euros per month, which is way below the minimum wage, plus food and accommodation. Who is the care recipient? Children over the age of 3, but there are no limits on the number of kids. The parties must include as well the services to be provided, here so-called day-to-day duties. We don't say service or work. The model agreement mentions as well that families shall arrange au pairs' working time to allow them to follow courses. Nevertheless, there is no obligation to attend these courses nor provisions on who should pay for it. 2 points are worth noting. So first, the model agreement does not cover all necessary features, and provisions are mainly less protective than labor law would be. It results in a system that favors individual negotiations, or what's been called law of the household workplace. In France, this construction of au pairs as a special category justifies a distinct status, which derogates from the application of employment law. In this scenario, au pairs, they are not included in the scope of the national collective agreement governing domestic employers and the domestic employment sector. So I turn now to Ireland, in which domestic workers do not have a specific regulation, but are entitled to the same rights as any other employee. In this sense, they are workers like any others. Au pairs are currently considered to be employees under Irish employment law. There is no specific legal definition for au pairs, nor a specific visa scheme for non-EU au pairs, and among participants I interviewed, they were mainly on student visas. The recognition as an employee resulted from case law, so a common law tradition. Case of labor exploitation involving au pairs in the country have attracted more and more attention since the beginning of 2000s, resulting in campaigns and advocacy movement. All these advocates has pushed cases to the Labor Court as well as to the Workplace Relations Commission, which is an administrative body with decision-making function. Oops, sorry. Oh, how can I come back? Oops, is it possible to come back? Sorry. Oh no.
Okay, it's coming.
Okay, sorry. Sorry, everyone. So a case in 2012 represented one of the first steps to consider au pairs as employees for the purpose of Irish employment law. More cases have followed and confirmed au pairs' employment rights. These cases involved usually breach of several general labor law instruments, such as Terms of Employment Information Act, Organization of Working Time Act, and National Minimum Wage Act. In spite of this protection, it's relevant to ask whether it is enough, or to what extent does the discourse of au pairs as a special category still impact to the access to employment entitlements. Okay, now I'm correct. We've seen that both models of regulation are different in the way that they regulate au pairs. In France, the special category discourse serves to legally justify differential treatment compared to other workers and domestic workers. In Ireland, this discourse is widely reproduced by private actors and jeopardizes au pairs' access to rights to which they are entitled to. For instance, almost no one among my participants knew their employment status and therefore their entitlements. Some of them had contracts with host families/employers, which were based on the models provided by some digital platforms. And these digital platforms, they shared the so-called European Model Agreement, which is the Council of Europe Model Agreement. In here, it's important to say that Ireland had not ratified the European Agreement on au pair placement. So I draw on some common challenges that au pairs face in both countries, which I try to illustrate with some quotes of my participants. So for instance, some participants, they said that they working more than 45 hours in France, receiving 350 to 450 euros. Another one working more than 35 hours, receiving 350 as well. In Ireland, on the other hand, working more than 60 hours per week, receiving between 800 to 600 euros, so way below the minimum wage. So among the challenges that I could identify, there is this high demand for flexibility and to work more hours than legally allowed. Poor payment in both countries, so several au pairs in France were being paid a minimum amount, whereas in Ireland they were commonly being paid well below the national minimum wage. Extra hours were usually not paid. There was a lot of uncertainties on one's rights, and I also include the overlapping between the law of the household workplace and the so-called, what I'm calling the law of the industry. So this idea of how placement agencies and also digital platforms set rules and standards for au pairs. Here I'd like to stress the potential of ILO Domestic Workers Convention in enhancing au pairs' legal protection and access to rights. Currently, 14 member states have ratified the instrument, including Ireland, but not France. Since the International Labour Conference that culminated in the convention, there has been some discussions on the inclusion of au pairs in the scope of the instrument. There is no specific mention to au pairs in Article 1st that provides definitions of domestic work and domestic workers. Nevertheless, the broad definition that it provides accommodates the inclusion of au pairs. Looking at the comments of the Committee of Experts on the application of conventions and recommendations on the Domestic Workers Convention, there were 4 out of 69 mentioning au pairs. The Committee of Experts provides interesting pathways to challenge this idea of special category of au pairs as a discourse that is used to legitimate exclusions, both in terms of entitlements and access to social rights. So on one side, it calls for the improvement of the effectiveness of legal instruments in jurisdictions that consider au pairs as employees. This was particularly the case of Ireland. So 3 comments. In this sense, being protected by employment laws is not enough if workers do not have access to those rights, to those entitlements. And besides that, on the other side, jurisdictions that do not consider au pairs as employees must provide au pairs with protections that are equivalent to those enjoyed by other workers. And thank you.
Right, we will move to you now with the questions.
Thank you. Oh.
Thanks. I'm left-handed, so thank you very much for today. So I'm really happy to be here, and so I want to thank Fabiola for the invitation and for your whole to be here today. So first, I just want to mention that my thesis, in my thesis, I focus mainly on temporary labor migrant workers who are women in the sector of agriculture, both in France and in Spain. And I focus on their access to social protection. So I mainly focus on the coordination of social security, the international bilateral agreements, and also the EU regulation. But today I want to focus on the role of the ILO Convention for their protection. Ok. C'est bon? Ouais. Non? Ok, c'est bon. So before really entering into the ILO Convention, I just want to mention the three types of temporary labor migration that exist in the sector of agriculture, both in France and Spain. And so the first one would be seasonal migration from third countries, which is regulated at the EU level under the 2014 directive, which provides for equal treatment for seasonal workers with national workers, including for social security, although there is a kind of restriction because member states can restrict the equal treatment regarding family benefits and unemployment benefits, which is the case, in fact, a little bit less legally, but well, let's say that normally they should be treated equally. And this seasonal migration exists both in France and in Spain. And in both cases, most of the seasonal workers are from Morocco. But in France, they are mainly men, while in Spain, they are mainly women. The second type of temporary labor migration is EU seasonal migration. So in this case, it is regulated under the free movement of workers, also providing equal treatment for these workers. I will not focus on this today, but I just want to mention that there is a historical and typical pattern of seasonal migration from Spain to France, where it is quite gender balanced because it's like a family migration most of the time. And then the last type of temporary labor migration is posting of worker. So in this case, it is regulated under the free provision of services because it's really the employer who has the right to provide services freely across the EU. Okay. And so in order to do so, they can send their own workers. In my case, in the case of agriculture, it's mainly in France. And also what is interesting for me is because most of the employers are from Spain. So it's mainly Spanish employers who send their workers to work in the agriculture in France, mainly the south of France, but also a little bit in the center. And in their case, it's the Spanish employers do not only post national workers or EU citizens, but also a lot of third country nationals, including people from Latin America and more specifically from Ecuador. So that's why I will take this example in the next slides. So as we are regarding the social protection of this worker first in the country of arrival, the first principle that must apply to them is equal treatment. And as I already said, more or less, the equal treatment principle in the case of social protection is widely or broadly accepted, and it is already in the EU directive on seasonal migration, but also in the bilateral agreement between Spain and Morocco and France and Morocco. So in the case of the seasonal migration, it's not that complicated, let's say. But then we have the case of posting. And in this case, we have two situations. So we have the situation where it is really posting as understood under the EU regulation on social security coordination. And in this case, we are before 24 months of posting or without any replacement. And so in this case, it is the law of the country of sending that applies. So in our case, it will be the Spanish legislation. And so if we take the example of the Ecuadorian workers to determine if they have equal treatment regarding social protection, we will need to look at the Spanish legislation that provide for equal treatment regardless of the nationality. But we also have a bilateral agreement and the Ibero-American agreement that also provide for this principle. And then we have the third situation, but like second situation in the case of posting, when it is a long-term posting, so more than 24 months, or when a posted worker is sent to replace another posted worker. And in this case, we need to apply directly the French law. And that is interesting also in this case because posted worker become a migrant worker regarding the EU regulation on social security coordination, because we will still apply this regulation, but not the article on posting, but all the article for migrant workers in a way. So in this case, equal treatment regarding these posted workers is regulated under the Article 4 of the EU regulation. But I also want to mention that in this case, the ILO Convention can also be interesting because we don't have any bilateral agreement between Ecuador and France. They don't even have a bilateral agreement regarding labor migration. So all their situation as migrant worker in France will be regulated under the ILO Convention on Social Security. And this is interesting for the second part of accessing to social security in the country of arrival with the principle of aggregation. Because equal treatment in the case of temporary labor migrant is not enough in a way, because as it don't stay enough to really fulfill the requirement to access to some social security benefits, we would need to apply the principle of aggregation. So in the case of seasonal workers, it is it is regulated under the bilateral agreement with Morocco for mostly all the branches of social security except unemployment benefits, as always. But then in the case of posted worker, so I would only focus on the replacement situation, we would have two situations for the principle of aggregation to apply. We would have the situation, the intra-EU situation, so we want to aggregate the period the Equatorian workers has contributed to the Spanish systems to the French one, so it will be under the EU regulation as the EU migrant worker, let's say. But if we want to aggregate the period between Ecuador and France, we will need to go under the ILO Convention 118, which has been ratified by both France and Ecuador, regarding healthcare, sickness, maternity, invalidity, survivor, and accident at work benefits. So in this case, we would be able to give more access to Ecuadorian workers in France thanks to this ILO coordination of social security. The other situation for temporary migrant workers is, as we said, they can't stay like long term during a long period of time in the country of arrival, so they would need to move afterwards. So normally they would come back to their country of origin. So in the case of seasonal work, it must be Morocco. But in the case of posting of worker, really, they can do whatever they want in a way. So they can come back to Spain, but they also can come back to Ecuador or go to another third country, but just these two situations. So in the case of seasonal workers, and so in moving in this case, we would need the application of the principle of portability of the benefits they could have in France, but so to portate that, to export them in their country of origin. So for seasonal worker, bilateral agreements with Morocco has also a broad scope of application of this principle. Even though in the case of France, we have a limit for sickness benefits for only 3 months. You only can have sickness benefits for 3 months if you go back to Morocco. But then for posted worker, we would also have different situations. So if we have the posted worker, like the normal one, we would have from Spain to Ecuador. And in this case, it's under the bilateral agreement between Ecuador and Spain. We will not use the Ibero-American one because it has a restrictive scope regarding the bilateral agreement, which is not the case, for instance, with Colombia, but it's totally different. It's always really complicated in this case. But from Spain to Ecuador, we would have the possibility to export maternity, invalidity, old age survivor, death, and accident at work benefits, but not sickness benefits. And the thing is, we could have the possibility for sickness benefit if both countries would have ratified the same ILO convention. But Ecuador has ratified the ILO Convention 118 regarding equal treatment in social security, but not Spain. But Spain has ratified the one on the maintenance of social security benefit, which has also a broad scope of application. So we can't use this new coordination to allow them to have more protection. Then if we take the situation of posted worker who replaced another posted worker, we would have two different situations once more. So if they want to go from France to Spain, easy, we look at the EU regulation on social security coordination, which also provide a broad scope of the application of the portability principle. But then if we want to directly go back to Ecuador, we would use the ILO Convention 118, which provides for the portability of invalidity, survivor, and accident at work under the Article 5. But I would think that we could have a broader scope of the portability principle under the Article 7 that provides for the possibility of the member states needs to ensure the conservation of acquired rights. And if we look at the Convention 57, the part on conservation of acquired rights mentions the principle of portability. So maybe it would be a possibility. So in conclusion, the ILO Convention, in the case of temporary labor migration, ensure a protection in absence of bilateral agreements, and which makes sense because ILO Convention and the ILO recommendation always recommend member states to please have new bilateral or multilateral agreements on social security, so they prefer the situation to be under bilateral agreement, let's say. But then it also, in a way, can create a second path of coordination, improving the protection for Ecuadorian posted workers. The limits are the low ratification or partial ratification of ILO Convention, which then may create an incomplete coverage. And another difficulty is the articulation between all this system of coordination, because we can't aggregate the periods of Ecuador, Spain, and France, as they don't decided together that they could. We can, in the case of Morocco, Spain, and France, thanks to the Euro-Mediterranean agreement that provide for this possibility, but it is not the case for all of them. And thank you, that's all.
Thank you so much for unpacking these regulatory challenges for these very specific sectors that are so much important for the governance of migration and protection. I would like to open the floor. Yes, Annette, please.
So thank you all four of you very much for really fascinating set of presentations. And I've been spinning the language of obfuscation that you put on the table, Marco, right from the start, and listening to these last two presentations. I kind of think I know where I want to go with that, because you're working with the text, but you're also really casting limits on the text. And through time and space, and especially scale, you're subverting the text, I would submit. And that comes through in your presentations, Audrey and Caroline. And so for Audrey, when you talk about the patchwork of bilaterals, and the really take the Convention 118 and others closely and carefully in a way that actually reminds me of how we used to talk about European social law, frankly. And the scale element is not only the law moving away from the individual, as Marco so carefully set out, but it's also, isn't it, moving from an understanding of law at a domestic level to thinking more systematically about what happens transnationally. And you're doing that, and you're doing what, you know, some trade specialists will say, oh, and then you get a spaghetti bowl of, right? And so how do you then move it to a place where you're seeing the way that you need to regulate across the board? And so perhaps thinking about a convention like Convention 118, not only in terms of who's ratified it, but what guidance it gives towards building the kinds of portability that you might need. And so I'm wondering, and this could be a question to any of the presenters, how this, you know, evocative metaphor of the birds of passage, you know, where does it take you in terms of how you understand the appropriate scale or the moving character of the scale, maybe in Nancy Fraser's terms, for this. And Caterina, I really love the juxtaposition that you make between France and Ireland and very different approaches to regulating, but then you ask, is this enough? And I kind of want to push you on the, is this enough? Because you showed it so powerfully through the quotes from the individual au pair, right? How do, and maybe the is it enough, how is the committee of experts showing us a way in which learning communities that have or have not ratified Convention 189 and can come to the place where in the absence of an express exclusion, we're really moving towards thicker coverage, right? Again, I guess to go back to some of the language that Marco introduced at the outset. So I hope that's clear, but really evocative and powerful work, all of you.
Anybody else who would like to add a question? Don't have anything online? Yes, please.
Hi, Jane Hodges, formerly of the ILO. Thank you so much, particularly as gender coming second, but I'd like to throw it to you, Audrey and Catherine. Will you one day be able to move beyond European examples? I know it's part of your project, but I've done a lot of work on ASEAN. We now have 11 member states. As of a few days ago, Timor has joined, and they've got a portability of social security agreement, soft law. It's an absolute spaghetti ball. It's an absolute mess in ASEAN. It's very, very hard for even to get ministries of the interior or ministries of labor to respond to questionnaires. I was responsible for a large ASEAN project looking at labor law and across the then 10 member states. But with the lessons, maybe it's not so much a question of could you do it, but to give the message to other researchers that what you do on this is really important worldwide. It's not just sending messages to employers of this kind of work in one region. And do you know anyone that's working on social security in ASEAN? Thank you.
Thank you. Do you want to start?
No, we finish.
Oh, okay. So we start on the order 1, 2, 3. Yeah, 1, 2.
Oh, okay. Thank you very much. I think there's not much answer. Just thank you for the comments, and I really think that CACR comments can give like just pathways to reflect on the. And I really liked what you said about the absence and how we could maybe use this to fulfill and ask if it could provide some answers. So I don't have an answer, but just observing the comments. Thank you so much. And concerning your comment, I know some researchers that have done research about au pairs in Australia, but it's still global north. So I'm not sure if it's what you mentioned, but the findings were more or less similar in the sense that, and it was quite impressive what the researcher has done. So what she found was that even in Australia, digital platforms were actually inviting host families / employers and au pairs to sign the model agreement provided by the Council of Europe. So you can see how there is this this implication of different orders and how it may impact and shape relationships in different parts of the world, even if the agreement is not legally binding to the country. So in Ireland, they also use the model agreement, and it's quite interesting because the country has not ratified, but is still Europe. So you can see the impact of different norms worldwide, and especially how powerful are the rules and standards set by digital platforms and intermediary agencies. Yeah, thank you.
Okay, so thank you for the comments. Answer the question regarding the scale. well, I don't really have a good answer. I mean, Marco will have a better, but the thing that I will say is, I think one of the problem with all the agreements and legal instruments regarding migration and so regarding social protection is that we always have, but I know that we can't really do otherwise, a national perspective on everything. We always think of migration from one state to another, but it doesn't work with temporary labor migrants because they are not going from Spain to France. No, they are going to Spain, to France, to Switzerland. If we just take the Europe thing, and if we take a Moroccan person, it's the same. Maybe he will go to Spain today, but then next year he will be in France. And so the Ecuadorian person, it's always too defined by national borders, while for temporary labor migrant, it's not working. So maybe we would need to rethink the agreement and the legal instrument, not as one place to another, but mainly as a movement. Like really they are moving around, and so we need to think like that. And I think, for instance, in the ILO Convention I was looking at, or even in the bilateral agreement, they always say to the portability, to apply the portability principle, it's from one place of residence to another place of residence, but it doesn't work for temporary labor migrant. Seasonal migrant, for instance, they can't change their place of residency. So they are never residing in different countries, they are staying in other countries. And if we just look at this term, staying, they would never have any access to social protection. So I guess the difficulty regarding scales is really this national, like this nation state perspective all the time. But I mean, I'm not a politician or whatever, so I don't really know how to do it better. And regarding going beyond Europe, I would say that it's a good idea, but of course, it's absolutely not in my scope for my thesis. Could be interesting to have other perspective. And if I only take the example of intersectionality, which is in my thesis, in this case, gender perspective or whatever, clearly it's not in Europe that I need to look at, but mainly in Latin America. we did all the gender perspective in law, it's always from that. So I think we need to reflect on the global south, and to be inspired. But yes, I only focus on Europe now. Thank you.
All right. So now I was supposed to give a better answer, which of course I can't. But thank you, Andre. But my point on scale and think transnationally, and I think Audrey already covered that part very well, in the sense that we really see with some of these movements that is much more complex than the simple bilateral situation. And I think in a lot of this, we are seeing the obsolescence of some thinking and even regulation on migration. And unfortunately, the ILO suffers a bit from that for honest and concrete reasons. So this is not a critique. It's more about being aware of this, and our vision of migration is clearly challenged. And that's why I like to reflect, like as a researcher, to reflect on this intra-EU posting of third country national, which really showcases this organization of migration paths. And it's really important to keep these things in mind. We're confronted with ideas focusing on agency and freedom of choices of migrants and so on. And when you look at the actual organization of migration paths, it's really hard to argue that a lot of this is not entirely organized by an industry. Okay, and it doesn't mean that the migrant has no an interest or even a consent, to some extent and under many conditions to this, but I'm just saying that it calls into question the debate on agency and life choices and the right not to leave or to leave or whatever. Anyway, thinking transnationally is the easy answer, I would say, for us, because in a way that's how we are grown and trained, and we are very transnational. I mean, I've only moved around in Europe, so not even the most transnational of the table. And instead what I want to do is to some extent the opposite, which is deflating and a bit sad and pessimistic, as befits my generation. But I think there is a national responsibility to stress, and it really the countries which profit and eat and live in clean houses and uncared for by these workers have a responsibility to at least give them their dues. And if somebody pays into a social security system, they should be able to draw from it. That's a very basic thing, but it is challenged by these situations of fragmentation, and this should be solved. And I'm really afraid of the idea of solution would be not to pay contributions, which of course creates the underclass of uncovered cheap labor. And this is really something we should be extremely careful about. And instead, if really we must go that way, it should be at least money that is given back to the migrant, which is not my preferred solution. But again, at least in terms of justice, they have paid in, they cannot draw from it, just give them back what they paid. Okay, again, lump sum. It's not what I want from a system of social security. But in terms of my vision, I like the transnational solution, of course. That would be my preferred option. It's always my first line of thinking. But if I go beyond that and I face the challenges of the international legal order that we have known so far, and it's really shaking in front of our eyes right now, I think that at least we have to insist on the responsibility of countries which benefit from temporary labor migration. And second, to some extent, appeal to their self-interest and to challenge this view that we just need to open the door as global north and people will come. And to some extent, at some point, you might have to fight to have the people that you need. And that maybe using these access to social security, the ability to export benefits and so on, might create patterns of migration which are more reliable for the receiving countries. Again, this is all very utilitarian, and I make this as an argument for the countries, not my preferred vision of the world. But I think this vision of loyalty in migration paths for temporary labor migrants might become important at some point, where we discovered that we can't just open the door and have everybody we need every year, season in, season out, and then send them back. So this might be a path to reinforce this idea of at least give temporary labor migrants what they are owed. Okay, not even more than that.
Thank you, Marco. There's a question for Audrey. If I may, I will read it. So the question is, if you have seen actual examples of social rights being claimed in practice, in this person's experience, even if the social rights exist, the administrative burden is so high in practice that no one is actually claiming the rights, including pension rights.
Regarding pension rights, there is a paper which is in French, I think, of Anouk Small-Quibrin, who talk about the Ecuadorian workers from Spain and France, and then going back to Ecuador, who has a lot of difficulty for old age pension. So I would just say to go to this paper for that. And then regarding social security benefit, I focus on in my thesis. Well, first I focus on unemployment benefits, and then clearly they will never have any kind of access to it. First, because in Spain, for instance, for seasonal workers, it is clearly written in the migration law that they can't contribute to unemployment benefits when they are seasonal workers. And I think that it is particularly a difficulty because contrary to France, who has really this idea that seasonal workers are temporary and must go back to Morocco and will never have permanent residency in France and can't really change their visa or residence permits even after the year is in year. Spain allows this change of visa and residence permit. So you have a seasonal permit for 4 years, but then you can obtain, claim a residence permit for 1 year as a worker, like normal, like temporary workers. And in this case, you will contribute to unemployment benefit. And I think that it is a real difficulty and problem, because it means that the 4 years you were in Spain, you can work up to 9 months during 4 years, like each year 9 months. But all this moment you did not contribute for unemployment benefits, well, then you are in Spain with during 1 year, maybe 2 years, and you may need unemployment benefits. And so in this case, because of these 4 years of no contribution, you will never have any kind of access. Then if I take the example of maternity benefits, in this case, it's really, really protective in a sense, like all the bilateral agreements. For seasonal workers, they mention maternity benefits. For posted workers, so the Equatorian the bilateral agreement between Ecuador and Spain also, but it's not the case for Colombia. Difficult thing. So you have this, and when I mentioned this situation with association who worked with seasonal workers, they all said, "Oh, but no problem at all. They are they benefit from equal treatment, so they have access to maternity benefit as Spaniards." They always say as Spaniards, but I can't be sure that it is true because they didn't really want to delve into this situation. Let's say. So yeah, and first, just to finish with France, it's true that the biggest difficulty for social security benefit, especially for portability and even aggregation, it's the forms, because you have different forms depending on your country and depending on the bilateral agreements that you have with Morocco. For instance, you're a Moroccan person and you are under the bilateral agreement on social security between Morocco and France. You have, I think, 15 different forms depending on the kind of social security benefit you want, on the principle you want to apply. And it's first difficult to know that you need that, and then to really be able to write it down, because maybe you don't even speak the language, so the forms is in French. Well, you have all this difficulty, and then the time. And even intra-EU migration, they told me the Spanish worker who work in the season in France, they told me that for unemployment benefits, they need 4 months before really having the unemployment benefits, between asking and having it. So I think the biggest difficulty is, as always, administrative burden.
You had a question? Anybody else? I was a bit, before we close, I was a bit curious, Audrey, as well, on these differences that you kind of mentioned, but not elaborated, on Ecuador and Colombia. And I have an interest, not only because I'm from the region, but also I'm wondering whether you see, I know your focus is in Europe, but whether these countries deliberately compete in the provisions that they negotiate in the bilateral labor agreements to place their workers abroad. Is something that comes out probably from your experience researching these workers when they are already in Spain and France, or you mentioned a few times it was a different. What is really different, and why do you think it is?
Well, the difference is between the bilateral agreements on social security, the Ecuadorian one. Don't remember the years, but I would say that I think the Colombian one is more recent, but maybe I'm wrong. And so the Ecuadorian one is really like has a broad scope, like the Moroccan Spanish one, let's say. Like it's really broad. You have a lot of social security benefits that are covered. While the Colombian one, I think it's the minimums you need, like sickness, I'm not even sure, but at least accident at work, old age, invalidity, like all the golden social benefit you need. And also Colombia only ratified the Ibero-American agreement, I think 2, 3, 4 years ago. Like it's really recent. So no, I think it's 2 years ago, 2023. So I don't really know why there is a difference. What I can see is a difference between the type of migration, at least regarding temporary labor migration, because seasonal workers are also from Colombia in Spain. Like a lot of them, like it's Moroccan workers first, and then a lot of Colombian workers. So maybe it's because of this idea that Colombian workers are temporary always in Spain, so you don't need to protect them that much because they are temporary. So you will just focus on the most important benefits for them. So invalidity and accident at work, let's say. But you don't really need to focus on maternity or sickness because they are not supposed to stay that much. While maybe the Ecuadorian and Spanish relationship is longer in a way, and they have maybe, I don't know, more refugees or whatever. So I'm not sure, but from what I see, I guess it's a different migration path that would explain this difference.
Thank you. That was very helpful, actually, to carry on thinking of our work. So we're coming to the end of our seminar, and I don't know, Marco, if you would like to say a few words. I will basically say thank you to everyone in the room and online for their participation and the questions. It has been quite clear, learning from different experiences, how we're still trapped in this methodological nationalism, even though we do a lot of effort to think transnationally, and we know that rights are transnational, but we're still caught up in this methodological nationalism, which is a reality that we face, but we also can utilize to protect these workers and to move as well to better enforcement. This is another area of interest for the ILO that we are working on, compliance and enforcement to whatever is there. How can we actually make it reach the workers? And the EU is always a laboratory and a space where we think these are afforded in paper quite better than in other regions sometimes, but we also see the challenges in implementation and what can we do about it. So me personally, I have learned a lot, especially on the things that we couldn't cover in our book, Christiane. So I think this is a good complement of the work that a lot of other people are already doing. We keep on, trying to move a little bit the boundary of the othering to create more inclusive societies. That's important for our work, and I will encourage everybody to continue engaging with this topic in spite of the current times. It's very important, and reach to us and the researchers here present, share your materials, either from research perspective, advocacy, legal, practical, economic. We welcome all analysis. So Marco, if you want to say something.
No, so I didn't prepare to close the thing. I thought Fabiola would just close it. So now I've been thrown the ball in front of the goalkeeper. So no, I will have to say.
We have someone. Berna. She's Berna is an author in our book, so she's saving you. Berna, yes, you have the floor, and then you go. Thank you, Alessandro. Are you still there, Berna? Yes. You need to unmute. You can't speak. Oh, so you were not saved.
Maybe it was a wrong raise hand. Yeah, hands down now.
Okay, so sorry.
It's okay.
Thank you, though.
It's okay, no worries. So no, I just take the opportunity to close to thank again Fabiola for the organization. All of you here, really, thank you very much, because I know finding time to just listen to somebody, it's a luxury these days. So thank you really to have found the time in your agendas. Thank you for all the questions which move our thinking forward, and just to say a few words as closing, as a small in the end research team of 5 people, of which again we have seen 4 today. It's been extremely interesting to deal with this topic, and my belief that led me to European Birds of Passage was really that this is a phenomenon that will stay with us, because again we know the compromise between the need for migrant labor and the call to absolutely close all borders possible every time. So this was my understanding that led me to propose the project, just because I think it is a phenomenon which will increase in importance, and it calls for more attention from us. And I think looking from a European perspective, it is important to try and work in ways in which the law can recognize this importance, and should recognize in terms of working on global justice in a very practical, real way, beyond historical debates, in a very today's contribution to our livelihood. And as lawyer, I feel I need to give again justice to all the empirical work being done by other social sciences. And in the end, we always arrive at the end, because there are people in the field that they find something, and then it grows and it grows, and it should arrive to policy and to law. And at the moment we are not too optimistic about policy, but law sometimes has a way to surprise you and being repurposed, reused creatively, and that's more or less what we want to advance. And I was happy to hear Adele also comment on this idea of what we are trying to do is really to create new ways to use things that we have and to redefine or define for the first time categories that are there and are underused, in my opinion, at the moment. And that's all. Thank you very much.
Thank you. See you next time.